Well, hopefully you would only appeal a case that you didn't win. That would be the first criteria. So if you didn't win the case, I mean, you might have to defend one, and certainly that happens when you're defending an appeal. But if you didn't win a case, you would consider whether the court had misapplied the law, abused their discretion in making determinations, if there was a clear error, which are always the easiest ones to win if there's been a clear error. So you need to consider what's going on with your case and have a cogent and full discussion with your client about what's going on and what the needs are and the chances of success. In Minnesota, when there's an appeal, you have to file a notice of appeal and a statement of the case. That just begins the process. There's a time limit to doing that. You need to do that within 60 days of the notice of entry of order that is the subject of the appeal. And then in Minnesota, they've adopted a mediation process that requires the parties in a family law case to proceed to mediation with an appellate mediator with the intent of trying to settle the case and resolve the case. And that does happen in some instances where you can resolve your case in an appeal. In other instances, you go up to the Court of Appeals, you draft your brief. It costs considerable time and expense in doing those. They're not cheap processes, so you want to be sure that you've got a chance of success or at least a good chance of success with winning this. And then after the mediation process has not been successful, you draft your brief, and then you get a notice for oral argument in front of a 3-person panel at the Court of Appeals, and you go make your argument, and then about 90 days later, the Court of Appeals will issue their decision, hopefully showing that you won your case.